Hello and welcome back to Vidyarthee Education. Today we will be breaking down the new Draft Arbitration and Conciliation Amendment Bill 2024, which was recently proposed by the Government of India, and this bill aims to enhance the institutional arbitration, reduce the court involvement, and ensure quicker resolutions to disputes. Let's dive into what this bill is all about and how it can change the arbitration landscape. Now, why is it in news? The Government of India has invited comments on the draft bill, which amends the Arbitration and Conciliation Act 1996. Okay. Now, the purpose of these changes is to boost institutional arbitration, reducing the dependence on ad hoc mechanisms and limiting court interventions that often causes delays in justice. Okay. Now, before we dive into the specifics of this 2024 amendment, let's take a quick look at the arbitration in India. Now, arbitration is an alternative dispute resolution mechanism where the disputes are resolved outside the courts by a neutral arbitrator. Or a qualified arbitrator. You can say qualified arbitrator. Okay. Now, the Arbitration and Conciliation Act 1996 governs these proceedings. Okay, it is based on UN-CITRAL Model Law 1985. Okay, now what does UN-CITRAL stand for? That is United Nations. We know that United Nations Commission on International Trade Law. Okay, now where is this headquarters? Write down in the comment section. Over the years, this act has been amended several times, and most notably in 2015, 19 and 2021 to make the process more efficient. Okay. Now let's talk about the key features of this amendment. Now first, renaming the act. This change reflects the omission of conciliation. Okay, we have omitted the word conciliation as those provisions have now been moved to Mediation Act. This has been moved to Mediation Act 2023. Okay. Now, emergency arbitrator. What does it say? This draft introduces the option of an emergency arbitrator who can grant interim measures before the tribunal is fully constituted. Grant an interim relief before the tribunal is fully constituted. This is essential for quick relief in urgent cases. Okay. Now, institutional arbitration focus. What is it about? Now, this bill promotes institutional arbitration over ad hoc arrangements, ensuring the disputes are handled by recognized arbitral institutions. Recognized arbitral institutions, leading to more efficient resolutions. Okay, for better efficiency. Next, Arbitration Council of India. Now, the ACI will play a central role in drafting model rules for arbitral proceedings and recognizing the institutions, further boosting professionalism in administration. So it will draft the model rules and recognition for institutions. Okay. Now, video conferencing. In keeping with technological advancements, arbitration can now be conducted via video conferencing, making it easier for parties to participate. Okay. Appellate Arbitral Tribunal. Now, for the first time, the bill introduces an Appellate Arbitral Tribunal to handle the appeals against arbitral award, adding an extra layer of scrutiny. Got it? Despite these changes, arbitration in India faces several challenges. Let's talk about them. Now, lack of arbitrator diversity. The majority of arbitrators in India are retired judges, which can sometimes lead to a lack of diverse perspectives. Now, lack of trust. There's skepticism about the independence and impartiality of some arbitrators, leading to reduced confidence in the system. Now, questions on independence and impartiality. Now, what about the judicial delays? The involvement of courts in arbitration proceeding often leads to delays in awards, making the process inefficient. Now, To improve the arbitration in India, several steps can be taken. First is promote institutional arbitration. Now, by encouraging the use of recognized institutions, we can reduce the reliance on the ad hoc arbitrators and improve the overall efficiency. We can reduce the burden on the ad hoc arbitrators. Now, we can strengthen the ACI, building trust and transparency. Trust and transparency. Through ACI will enhance the credibility of the arbitral institutions and arbitrators. Okay. Now, digital arbitration. We need to embrace digital arbitration. Utilizing video conferencing and other digital tools will speed up the processes, making arbitration more accessible. Now, to reduce court interventions, now limiting the scope of judicial intervention will ensure that arbitration remains a faster alternative to traditional litigation. Understood? In conclusion, the Draft Arbitration and Conciliation Amendment Bill 2024 is a significant step toward reforming the arbitration landscape in India. It seeks to create more efficient, transparent and professional system, reducing the delays and enhancing the use of institutional arbitration. Now, if implemented effectively, this could be a game changer for dispute resolution, putting more focus on the institutional arbitration. So this was all about today's topic. Now, thank you for watching. Don't forget to like, share and subscribe for more updates on such news. We'll meet you in the next video. Till then, keep learning and stay curious.